Okay, so let's talk about something well, it's a really big deal. For any parent of a child with special needs, that 18th birthday is a massive milestone. And honestly, it can feel super complicated and a bit scary. But it doesn't have to be. We're going to break it all down so you can build a plan that's simple and really works.
So, this is the question that's probably on your mind, right? Your child is turning 18. What actually happens? Because when that day comes, the entire legal landscape just shifts. Your role as their parent, in the eyes of the law, fundamentally changes. And that's the piece we really have to get in front of.
And this all comes down to a legal concept called the age of majority. It means literally overnight, your child is considered an adult. And all those rights you had to talk to their doctors, to be in their school meetings, to manage their finances, they don't belong to you anymore. They are automatically transferred directly to your child, whether they're ready for that responsibility or not.
Now, I know hearing that can feel pretty intense. I get it. But take a deep breath. This is not a time to panic. It's a time to plan. There are really clear, well-established ways to make sure you can keep providing the support your child needs, and we're going to walk through every single one of them. So, when you boil it all down, you're really looking at three main paths you can take. Each one offers a different level of support that you can match to what your child actually needs.
But before we even get into what the options are, we have to talk about the philosophy behind the choice. This right here is your North Star. The goal is not to take over, it's to find the least restrictive alternative. Basically, what's the smallest amount of intervention we can use that keeps them safe but gives them the most freedom and independence possible? That idea should guide every decision you make.
Okay, so this table lays it all out really nicely. Look at that middle column, court involvement. See how for power of attorney and supported decision-making, the answer is no? Those two keep the power with your child, just with different kinds of help. Then, all the way on the right, you've got guardianship. That's the only one that involves a judge and actually transfers the legal right to make decisions away from your child.
All right, let's kick things off with the one you've probably heard of the most, and for good reason. It's a really flexible and powerful tool called a power of attorney.
So what is a power of attorney, or a POA? It's simply a legal document where your child, the principal, gives you, the agent, permission to make decisions for them. But here is the absolute non-negotiable part. Your child has to have the mental capacity to get what they're signing. They have to understand what the paper does and what authority they're giving you. That's the key that makes the whole thing work.
And a POA isn't just one single thing. You can actually have different ones for different parts of life. A financial POA lets you help with things like banking or Social Security benefits. A medical POA keeps you in the loop with doctors. And then there's the one that people forget about all the time, the educational POA. This is so important because without it, after they turn 18, you legally don't have a right to be in their IEP meetings anymore.
You also get to choose when it kicks in. A standing POA is like flipping a light switch on. It's effective the second it's signed, but a springing POA is different. It only springs into action if a specific thing happens later, like a doctor officially saying your child can't make decisions for themselves anymore. The one you choose really just depends on what makes the most sense for your family.
Okay, so that leads to a really important question, a big what if. What if your child just can't understand what a power of attorney means? That requirement for capacity isn't flexible. If they can't give informed consent, a POA is simply off the table. But that's why we have other tools. So let's look at the other two big options when a POA isn't the right fit. And really, you can think of these as being on opposite ends of a spectrum of control.
And this slide just cuts right to the heart of the difference. It's all about one word, rights. With guardianship, a court removes the individual's legal right to make their own choices. With supported decision-making, or SDM, the individual retains all of their rights. They just build a team of people they trust to help them figure things out. So let's be super clear about guardianship. This is a big deal. It's a formal process that happens in a courtroom in front of a judge. It's meant for situations where a person is legally found to be unable to make safe decisions for themselves. And because it involves taking away someone's fundamental rights, it's always considered a last resort. Supported decision-making, on the other hand, is the complete opposite. It's not about taking over, it's about propping someone up. So instead of a guardian just deciding things, an SDM team might help your child research options, talk through the pros and cons, and practice what they want to say so that they can be the one to make the final call. The person is always in the driver's seat. And who can be on this team? Well, look around you.
It could be family, sure, but it can also be friends, a trusted neighbor, maybe someone from your church or a service coordinator. It's literally anyone your child trusts. Each person can help in a different way, creating this amazing, personalized safety net of trusted people.
Okay, we've gone over the options. So now the big question is, how do you actually turn all this information into a real plan for your family?
It really breaks down into a pretty clear 4-step roadmap. First, you've got to honestly assess what your child can and can't do. Second, you have to talk with your child, with your family, about what they want for their future. Third, and this is crucial, you consult a pro. And finally, you get it all down on paper and the right legal documents. Now, that consult step is huge. You don't want to just walk in blind. Go in with a list of questions. You need to ask them about their specific experience in this area of law. You need to know if their plan will affect government benefits like SSI. And make sure they're going to create a custom plan for you, not just hand you a generic form.
And let's just take a moment to remember what this is all really about. It's so easy to get lost in the legal jargon. Guardianship, POA, springing, durable. But at the end of the day, that's not what this is about. This isn't about paperwork. It's about thoughtfully and lovingly designing a future for your child. It's about creating a safety net that protects them, but also honors their dignity.
So I want to leave you with this one thought, a question to really mull over as you start this process. How can you use these tools not just to protect them, but to truly empower your child for a life filled with as much support and as much independence as possible?